I'm going to say good afternoon and welcome to today's local government education program that's being provided by the Illinois Association of County Board Members and the University of Illinois Extension. We really appreciate the opportunity for programming and collaboration in this most difficult time. My name is Kathy Brown and I serve as the Community and Economic Development Educator for the University of Illinois Extension. For sound quality, we will be muting all the microphones during the presentation. Only the speaker's voice should be heard. If you have any problems with connecting, add those questions into this chat space and we'll monitor that space and post comments or questions to the speaker at the end of the presentation. If you should lose connection, there is a dial-in number that Nancy has placed in the chat space as well. And that dial-in number, along with the meeting ID and password, should allow you to access the program by listen mode only. Today's webinar is COVID-19 update, and it will be presented by Heil Roster, who are active legal partners for the Illinois Association of County Board Members and the County of Illinois Risk Management Agency, or CIRMA. Our programming today was developed, as I said, with the Illinois Association of County Board Members, who have lent their legal and HR consultants to discuss the lingering legislative and unemployment issues related to COVID-19. While our speakers will not be able to give legal advice as part of today's program, local officials will have a chance to ask management advice during the question and answer time at the end of the program. And we will be making a webinar available on our local government education website and YouTube channels. All the participants in today's program will receive slides and links to the resources for the recording of today's program. So to get started today, I'm going to ask Kelly Murray, the Executive Director for the Illinois Association of County Board Members, to give a brief welcome, and I'll follow with an introduction and lineup for today's webinar. Kelly?
Oh, thank you. Yes, thank you, Kathy, and thank you to everyone who's joining us this afternoon. As Kathy mentioned, we want to reach out to all of you as this COVID-19 situation continues, and we really want to thank the University of Illinois Extension for allowing us to partner with them on this platform. What we're going to be talking about, I think, specifically today is a little more HR related with respect to employee management. I know our first COVID-19 session focused primarily on the FEMLA changes and a lot of legal aspects with that. So today we're kind of carrying on from that. We know that as this pandemic has progressed, there's going to be some actions going to be needed to take up by the counties, and we want to make sure that on the employment management side you have that sound advice to move forward. What I would like to start with today is just to give you a brief update on what we're working on with respect to some of the state actions and measures and recommendations we're making to the governor's office and also lawmakers. The House Local Government Working Group met this past Wednesday, and Taylor Anderson and I presented on that working group agenda to talk primarily about county issues related to COVID-19 and what we're dealing with the emergency situation, and also recommendations and assistance we are requesting from the state. With that, I kind of want to talk a little bit about primarily the main issue we're focused on right now is the federal funding that is going to be coming to the state of Illinois. We know in the CARES Act allocations that the Coronavirus Relief Fund made about $5 billion in direct federal funding coming to Illinois, and 45% of that is sort of set aside for our largest units of local government. So in Illinois, that means obviously the city of Chicago, and we have the 5 counties of Cook, DuPage, Kane, Lake, and Will who are going to get that direct funding. The other 97 counties, you're going to be able to access the emergency fund. But what we're working on as an organization, as the association, is trying to move this in a direction so that potentially the local government shares of the CARE Act are going to be distributed on a per capita basis. this should be done outside of those largest units. We want to ensure that all counties in the state are afforded that emergency funding. We know that every county is going to have expenses and also issues related to COVID-19, and we want to make sure that that is dispersed in that manner. We are seeing other states move in a different direction with respect to the CARES Act. Some of them are wanting, counties to look at their expenses, incur them, and submit for reimbursement. So that would be very difficult during this time. So again, that is one of the biggest issues we're promoting right now and working on, is to see how those allocations from the federal government to the state are going to flow down to local. We know the federal government is working on a fourth package right now that will include state and local governments. So we are staying in communication with the Illinois congressional members in our hopes to help move that in the positive direction as well. So we want you to know that we're on the front lines working for you very hard in conjunction with the state issues as well as the federal. One of the other issues that we brought forth on Wednesday was the property tax cycle. We know we've got probably about a dozen counties now that have taken action more on the agenda to change the property tax cycle, but we're getting a lot of push by lawmakers to make this somewhat mandatory, and we don't want to see that. We want to make sure that the property tax collections and obviously that local decision, which is subject to change, stays that way through the county, working with the county treasurers and the county board. Not every county has the same collection calendar or cycle. For example, Rock Island County has a four cycle collection process. So we really feel that this needs to stay a local decision for a reason, and it needs to remain as such. So we're making sure that we're pushing on that. Many of you, like I said, have taken action. We did get some feedback from lawmakers with respect to, the penalties and fee waivers and interest penalties and things like that. We feel that is something that many of you might be able to do, but changing the cycle should be left a local decision. A couple other things we talked with the working group about was primarily, continued support for the Open Meetings Act executive order. We're also dealing with some issues regarding our public hearings. And we're asking for maybe the Illinois Attorney General or someone to kind of provide a little additional guidance to our local officials right now with respect to conducting the public hearings. We still have issues going on with special use permits, zonings, and things like that that need to continue. And that makes it difficult when we have to have those public hearings and collectively have the public available to do that. So we're asking for some additional guidance on that as it's related to the OMA. The other thing we're working on a lot is just trying to make sure the state takes a look at all the grant deadlines, where they have that flexibility to allow continuance of those reporting deadlines and the gather reporting. We've thrown out there that maybe October 1st would be a better cycle for the data. We don't know yet where we're going to hear back on that. The other thing is, and I know this is usually not part of our agenda, but we did hear from the Chief County Assessment Officers with respect to the homestead exemption. This is another area right now where we're thinking it might be to the benefit of the public that those homestead exemptions just be extended for a year based on the current records you have. Reason being, it's very difficult right now for many of our seniors or people with disabilities to get out and get those forms filled out, also notarized and things like that. Now, many counties have pushed that down the road. We appreciate that, but we don't know how far this is going to go. So again, that might be an opportunity just to see if we can get that exemption in 2019 to fold over into 2020. A couple other things, and then I'll turn it over to our other speaker. We wanted to talk a little bit about our labor and employment relations, and that's what we're going to be talking about even later today on the agenda with respect to furloughs and layoffs. We know those actions are coming. They're forthcoming by many counties and cities, but those could ultimately be subject to some grievance and arbitration under the collective bargaining agreements and unfair labor practice change proceedings. We're going to have to be cognizant of that and take a look at that as we move forward. This is sort of unprecedented for many of our counties with respect to layoffs and furloughs. We know it's a very, very difficult decision for many of you to make. So again, we want to make sure that whatever processes you take, you are within your right to do that, but we also want to make sure that management of those employees and the documentation and everything is done precisely. A couple last minute things. We're talking about some short-term borrowing with the state. Right now, anything for short-term borrowing from local governments, the two options that are available to county governments under the county's code require everything to be repaid with property taxes. As you know, this is probably not going to be a good time for all of you to come out of this and go and look to raise property taxes. So we are putting forth some ideas with the state to maybe provide local governments with a little more liquidity with respect to some of the funds or how to replace some lost revenues. The other thing is our court systems. As we know, the backlog of cases is becoming pretty high in many, especially in many of our more populous counties. So we're looking for maybe some emergency orders that will be put in place coming out of this too, that will help us to maybe get those numbers reduced quicker than we would anticipate going back to the general process. Some of that we're asking for is sort of the video conferencing as a means and other things, closed circuit, things we can be doing in the meantime, especially regarding juveniles and others, to be moving some of these things forward so that that backlog may be able to ease up. Lastly, we're looking at trying to make sure that the infrastructure capital improvements, the capital construction program things continue to move forward. Also, distribution of all of our revenue. We are asking if at minimum it could be 100% of what was distributed last year, so that your income tax, motor fuel tax, everything, video gaming, everything when it opens back up, is put back to that level and not decreased. We want to make sure that we can bring that revenue in as quickly as we can from the state. Lastly, I want to talk a little bit about our public health departments. They're dealing with a lot on the front line, and we have requested that the Illinois Department of Public Health take a look at the track and trace for the COVID-19 positive cases, especially at the long-term care facilities. We know there is high volume there, and our local health departments are probably going to need some assistance. So again, we've kind of put that forward. Now, our list is very long. Some of what I've told you today is the condensed version. These are things we are working on for you. I want you to know that we will continue to solicit input from you. We know there will be other changes coming that you may need assistance on. So again, we provided a survey link. You all should have that. And I would hope that you would continue to communicate with us, because Taylor and I will continue our part here in Springfield and Chicago as those local government working groups meet. And they are planning, I think, another meeting next week. We will continue to bring these issues forward. I do believe that in the general consensus of many of our lawmakers, they are trying to be of assistance. And anywhere that we don't need to possibly take legislative action or an executive order can be put in place, we are working on that to do that. So we hope that some of what we talked about today, we will be able to make some exceptions and get this through, even if it's on a part-time or short-term basis for the county government. So thank you, Kathy, with that. And we can turn it over to Jessica unless there's any questions.
Thank you, Kelly. Let me give just a really brief introduction for our keynote or speakers that are going to follow. I think we're really fortunate to have such a great lineup for today's program. And just a reminder that even though your mics are muted, you can still have a conversation with the presenters by making comments in the chat space, and we'll be sure to share those out at the question and answer period. First in our discussion, and again, there will not be slides, but we'll have a conversation with Jessica Bell, who is a partner with Heyer Royster. Jessica focuses her practice on the defense of insurance clients and employers in workers' compensation matters. She has joined the firm with extensive workers' compensation defense experience and has appeared before the Illinois Workers' Compensation Commission representing employers and insurance companies across the state. Following Jessica will be Donna Rogers, and Donna Rogers is the owner of HR Consulting and serves as a consultant for the Counties of Illinois Risk Management Agency. She graduated magna cum laude with a Master in Education in Human Resource Development from the University of Illinois in Urbana-Champaign. She has senior certified professional certification from the Society of Human Resource Management, and most recently earned the International Public Management Association certification professional designation. And she regularly delivers presentations among professionals at seminars and conferences, and internationally has guest lectured at several universities. So at this time, I'm going to turn it over to Jessica, and she'll give us a brief update on legislative matters or legal matters. Jessica?
Sure, thank you. So I don't have slides because this is really a fairly brief update. As noted, I practice in workers' compensation, and 2 weeks ago we talked about doing this presentation and talking about some pretty significant changes to the Workers' Compensation Act that came about as a result of COVID-19. Since then, there have been some more changes, undoing those changes, and all of those changes have resulted in not having a whole bunch to talk about substantively. But I did want to make sure that you all know what's going on. So April 16th, the Workers' Compensation Commission chairman and the commissioners, because they voted on it, passed an emergency amendment. That emergency amendment created a rebuttable presumption that should an employee, an essential employee, contract COVID-19 while working, there is a presumption that that condition was related to work. And there were some other connections that they made, because they said it's presumed that it arose out of and in the course of employment, and that it was causally connected. All of those are things that the employee would have to otherwise prove. And a whole bunch of discussion came about in terms of, well, what does that mean? It's a rebuttable presumption. My local news actually ran a short little story on it and said that automatically everybody working now gets workers' compensation if they have COVID-19. And that's not at all what was created. Pretty quickly thereafter, a week after, on April 22nd, the Illinois Manufacturers Association and the Illinois Retail Merchants Association filed a lawsuit in Springfield requesting a temporary restraining order to prevent the enforcement of that emergency amendment. It would be preventing employees from claiming that rebuttable presumption and getting workers' compensation benefits. There were a couple of reasons why. We don't need to talk a lot into it, but at the end of the day, the judge in Springfield granted the temporary restraining order, which meant that that emergency amendment was not able to be used until there was a final hearing on it. It was just a temporary restraining order. There was a schedule set for briefing, there was a schedule set for another hearing, and during that time, the state of Illinois, the Illinois Workers' Compensation Commission, would have to prepare a response and then appear at the hearing. None of that happened because April 27th, just this past Monday, the commission met again, and the chairman made a motion which was agreed upon by all of the commissioners to withdraw that emergency amendment. And he cited two primary reasons for withdrawing that amendment. The first was the cost of defending it. Obviously, litigation can be pricey, and with the fact of having to brief the amendment, to brief it like the judge asked for, appear at hearings, and then as the second reason, but also for further concerns over the cost, was the fact that he wasn't necessarily confident that he was going to prevail. Now, he wasn't saying, I realized that I shouldn't have done this, but with a lot of the uncertainty over how it would go, he didn't think it justified the cost. So effective April 27th, they withdrew that emergency amendment, and now all of it goes away, essentially. So I just wanted to make sure that you were all up to speed on that and know that that amendment no longer exists. It got quite a bit of action initially with everyone talking about it. What does that mean? Automatically they get benefits. Are there opportunities for defenses? How do we defend in this rebuttable presumption issue? And I want to make sure you know that the next step happened and that it's gone, and you don't have to worry about those things for now. Now, that being said, if I'm being completely honest, I'm sure something will happen. There will be some changes to the Workers' Compensation Act. There should be some legislation to address some of these things, but it will happen probably in a not so emergent basis. It will happen after a proper open meeting where discussions and the public can voice their vote, and it'll happen with a bit more thought process. And when it does, there are still going to be things that need to be flushed out, and we can follow up depending on when or if that happens. But for now, there is no longer rebuttable presumption. The Workers' Compensation Act applies as normal, as if basically what happened in the last 2 weeks never even happened. So that's where we're at. And I'm not planning on staying on the rest of the call, but if somebody has questions, I'll stick around for just a little bit. But somebody can always reach out to me if you have questions about that. If you have questions about the non-action that's going on. So that's just my quick update on the legislative things that have happened in workers' comp, and that's all I have on that. Thank you.
Thank you very much, Jessica, for sharing. And as she said, if you had questions, to put them in the chat space, we'll make sure to get those out to others. And at this time, we want to turn it over to Donna, and we'll let her begin her presentation at this time.
All right. Well, thank you, everybody. And I do want to mention, just because in the very beginning, it did mention that the presenters were going to be from Heil Royster, and I actually am from Rogers HR Consulting, and my connection here is through CIRMA, as I am an HR consultant for CIRMA, which is the Counties of Illinois Risk Management Agency. And I know, having looked through the roster yesterday, I do know there are some folks on the call that I serve. So welcome, those of you who know me. I am not an attorney. I am a lifelong HR consultant, so I am going to be providing human resource management information on the following topics as we proceed here. So the topics that we'll be talking about, I will give you a very quick IDHR update on the sexual harassment, only because it came up this week. You should have received the press release, and I'll talk very little about that. I will hit on some topics for the safety, layoffs and furloughs. We have been getting a few questions regarding that topic in particular. The FEMLA Plus that came out because of some of the federal laws and the changes and the time off related to that. And I'm going to talk a little bit about employee documentation that actually Andrew from Heil Royster talked a little bit about a couple of weeks ago. So I'll first start off with the sexual harassment update. You may have already seen the press release that came out just a couple of days ago on April 28th that mentioned that the training module is now updated. It was expected to be out there and available in February. It is now available there at the end of April, and you can go to the IDHR site and download what you see here, which is the first page of the slide deck, which is about 35 pages, and it's very text intense. And I believe it is primarily that way because not everybody, not all business owners and business managers are trainers by trade, and they definitely want the content to get out there to the employees. So the content has not changed from what they put out there in February that said basically this is what needs to be trained on. So it's really been transferred from what they put out there in February to a slide deck. And so that's available. There is on the very last page a sign off that should be every employee should sign, and then that copy should be maintained in the personnel file for the employees. Municipality, employer, whomever it is going to be responsible for maintaining those training records. It is not going to be IDHR. They are not going to have some major database recording any of this training. They will come and audit you, potentially, but they are not going to maintain these records. So please make sure that you are maintaining the records of the training yourself as the employer, as the manager. The other question we've had, and I've had these in my trainings that I've done for CIRMA, and I'm always going to answer the same thing. Should the elected officials be trained? I'm going to say yes. Are they officially employees? On paper, no. But they are actually listed in the act as one of the people that could be reported specifically, and therefore I really think they should be trained, because they need to be holding the employees accountable, and they should know what the employees are being held accountable for. And because they are specifically named as a person who could be accountable, then they also should know what they're being held accountable for. So I do agree, in my personal opinion, they should also participate in the training. And it also is going to help with morale if employees, if the elected officials also participate in the training. So those are just a couple of questions that we've already been receiving through the CIRMA hotline, and we just wanted to answer that for you, for everybody who's on the call. All right, so that's it for sexual harassment. Let's move on to what you're here for today, and that is COVID-19. We will go ahead and start with what is occurring today. Because of the governor's requirement, every employer is responsible for providing their employees with face coverings if those employees cannot maintain a 6-foot social distance at all times throughout their workday. Now, I already had to personally go out to a workplace, and I noticed already a particular workplace that was not maintaining a 6-foot social distance, and none of the employees in this workplace had a face covering. But I'm not the face covering police, but who knows who's going to be. But that is actually the requirement, that the employer has to provide that if they are not able to maintain that social distance. So so that's the main thing for the employer based on the new government directive as of today. All right. There are, and there have been, these business entrance signs. And I believe as we go, Nancy's going to be posting some of these documents up in the chat box for you to get available to you. And I've also put links on them in the slides in the notes section. So once you get a copy of them, you will also be able to have a copy of these too. But this is a particular sign that you could put out in the doorway so that people can see customers, patrons, residents that are coming into your buildings, if they are, if it's an essential place of work, and also your employees, so that they know, who should and shouldn't be in the building based on whether they've been in contact with somebody who has been exposed to COVID-19 or has any symptoms. your number one priority during this pandemic is to maintain the safety of both your employees and whoever your patrons are. So I chose a quiz to participate, and in the chat box there is an opportunity to use a to use the yes and no chat, and I'm trying to make that a little bit bigger for me to see. So you can do that if you want to, or you can just play along and not participate, and I will show you the answers. But the quiz was actually on the SHRM site. SHRM stands for the Society for Human Resources Management, if some of you haven't heard of that. And Gallagher, which is the actual provider of the CIRMA insurance that we use, actually provided this quiz. So I thought it was appropriate to use this quiz in this training. So so some of the topics we will use through this quiz, and then some of them I will expand a little bit more on. So this one starts talking about specifically those exposed essential employees that I was mentioning earlier in reference to the specific, the face coverings that we're having to need today. So when allowing essential employees who have potentially been exposed to COVID-19 to continue working, employers should A, take the employee's temperature before each work shift. B, require the employees to disclose to coworkers the potential exposure. Or C, require employees who have COVID-19 symptoms to wear a face mask while at work. Or D, all of the above. And the answer is A, take the employee's temperature before each work shift. That was actually approved most recently by the EEOC. You can actually do that. And the EEOC not only approved the taking of a temperature, but they also provided some additional guidance that I've provided here as well for you. The one thing that I would recommend to you is if you do take the temperature of your employees, you keep that temperature confidential. And if you can, I would also take the temperature in a confidential way. So first of all, you have to keep a 6-foot social distance. So if you're going to take the temperature, for example, of your employees, then you keep before work, let's say, you keep a 6-foot social distance as they're coming into the workplace. And if you have a room where they can take the temperature and then leave, if they happen to have the temperature, then that is good because it's private, and they can also leave out a different door or something like that. But maintaining confidentiality would be a very good idea. And then there's this additional EEO guidance as well. I'm going to not read everything on here because we are short for time. And I know we only have so how long does things stay on the surface? You probably have heard this before. So this question is kind of a true or false. If it's on the surface more than 7 days, do you have to clean it or not? Is that true or false? The answer is true. If it's over 7 days, you do not have to clean it. But if it's a surface that people are going to be touching constantly, then you do have to clean it. And you should, make sure employees are constantly cleaning the surfaces as well. So keep that in mind. Does your organization have this type of plan? What type of plan is that during a pandemic and other situations? Is it emergency communication, workplace coordination, business continuity, or a flexible work plan? And in this case, it is a business continuity plan. And I'd ask you, if we had more time, how many of you had a business continuity plan before this outbreak? And I would also remind you to have make sure that it includes things like payroll and where employees are going to report to, and various other HR kinds of things, because a lot of people think about technology and where the systems are going to take place, but they don't always think about the people kinds of changes. One thing that I have always used, especially, we had some really major tornadoes here in the Springfield area back in 2006, and ever since then, many of the companies I've been dealing with have used ready.gov, which has a great deal of wonderful resources on both with the employee and the employer, and you can provide information for both yourself and the employer. But you have to think about the impact. What is your strategy going to be? What plans do you have in place for this, that, and the other thing? And you should really test it out. One of the things that I found out once in a manufacturing company is I had a test going on with regard to a fire, and I had the fire company come down and do a drill, and we had all the lights in place, and we had a fire drill, and 3 of our people did not come out. And it was because the sandblaster was so loud that they could not hear the noise from the alarm, and the lights in that area did not get to that particular part of the building. So you really need to make sure that everything works, and that's important for you to test. The other thing is do you actually have, did you actually have it? According to SHRM, only they had just done a test, only 34% of employers did actually have a plan before COVID-19. And of those that actually did have a plan, over half of them had no plans in reference to any kind of communicable disease. So now over 53% of companies are actually saying, okay, we need to update our business continuity plan now. So also OSHA, and I have working with a lot of counties lately, I always get a little bit of pushback because Illinois, if you go to the OSHA website, OSHA says it's for private employers, which it is. But if you go to the Illinois OSHA website, it does say that it does follow OSHA guidelines and for public organizations. So with regard to OSHA, there was some questions about COVID-19 related to reporting illness on the OSHA Form 300. So this question, true or false, employers are excused from reporting suspected work-related COVID-19 illnesses under OSHA record-keeping requirements due to the designation of COVID-19 as a global pandemic. And some people are thinking, well, yeah, why should we have to record that? How do we know whether they got it at work or if they got it at home? Could have got it a number of places. But the actual answer is false. If you actually know that they got it at work, if 2 or 3 of your employees got it, have it, it's probably they're getting at work. You may be able to say they did get it at work, but if you don't know, if only one person has it and you don't have no clue, you don't have to track it down and find out where they got it specifically. But if you know for sure, you're pretty sure, you do have to report it. And on the left here is a copy of the required OSHA Form 300 that you should be always using every year, logging all of your work-related injuries and illnesses where people have a recordable incident, which is beyond first aid. They're missing more than a day's work, half a day, just going, leaving for a part of a day. It might be just to check it out, but if it's first aid, that's not a big deal. But that is supposed to be kept, and then there's a summary of this that needs to be posted once a year. The right-hand side is the Illinois Department of Labor required poster as well. The one on the left does not have to be posted anymore, but it does need to be maintained. Only the summary has to be posted. So in addition, the other thing I want to mention too is if you do find out you have to have, you have a situation where you have COVID and you have it recorded on that left-hand poster, then according to this additional poster on the left, this came out in 2015, if somebody dies, which is kind of halfway down there, it says that you have to report a fatality, or if they are hospitalized, you have to report within 8 hours if they die, or within 24 hours if they are hospitalized. So if you know for sure that they are, in either of these situations because of contracting it at work from another coworker, then you have those OSHA responsibilities. So keep that in mind. There is an entire COVID-19, guidelines with a great deal of really good OSHA information in that as well. All right, moving on to the next thing is one of the new federal laws. It is not necessarily for everything. I like to think of it as FEMLA Plus. In this question, it is asking if it allows an employee to take paid FEMLA leave if he or she can't work or telework because of either the employee's minor child school or child care service is closed, the employee has been advised by a healthcare provider to self-quarantine, the employee is experiencing symptoms, or all of the above. And the answer actually is A, the employee's minor child school or child care service is closed due to COVID-19. Remember, it's called Families First Coronavirus Response Act, and it is an addition to FEMLA. We do still have regular FEMLA, and think about those first two questions. The second two questions. The second two questions relate to the employee, right? The employee has been advised by a healthcare provider to self-quarantine. The employee is experiencing symptoms of COVID-19. That relates to the employee's own illness. So think about, we still have FEMLA. If you have over 50 employees, then you may have FEMLA coverage already. There is, with the additional FEMLA, the difference was too that the person only has to be there for 30 days versus the regular FEMLA is they have to be there for 12 months. So there's some differences there. So keep that in mind. But employees can request the expanded FEMLA leave. Employees may have reasons for their own related illness Remember, in these cases, employees are not, the hospitals and the doctors are asking employees not to come to the doctor's office, or the hospitals. In most cases, they're asking them to call a telenurse, and they are most of the time having them drive up and swab and take care of themselves at home if they can, unless they're they're having severe symptoms. So there is actually a FEMLA form for recording self-certification. I've put it in the notes here, but I also have a form that that should be put up in the chat box, so that you can see, you can use this if you are not aware of it, and it has the information that the employee should keep track of while they're home and while they're quarantined, and it keeps track of things like their temperature and various other things. So that way the employee, since they're not able to go to the doctor, they're actually able to give you their own return to work information, so that they can come back and show that, yes, I've self-quarantined, and then I test that I've not had a fever for 3 days, and I've been taking the medication that the doctor has told me, and various other things. So those are actually from the Department of Labor. This is the thing that Andrew mentioned a couple of weeks ago. We always have to have a personnel file, and anything medical has to be kept in a separate medical file for employees. I always encourage people to color code those. Usually I'll recommend a red file for the medical file. Now with COVID-19, they're recommending that we have a third file. So of course, you wouldn't have it on every employee, but just employees that you've been dealing with COVID situations, you would have a COVID file for those employees. So this would be one if they have to have a self-certification return to work form for them. So you should have already posted this particular form. If you have employees that are working from home still, and will be for the next month because of the new expansion here in Illinois, this should also be emailed to them. So that should be taken out too. I wanted to share this with you. This was the additional SHRM research that I mentioned earlier about what employers are doing with regard to the time off. And we mentioned that in the previous slide, and this upcoming question has to do with this as well. So the next question is, can employees save time on the books? Let's say you have a PTO policy, you have a vacation policy, maybe you have personal time, anything like that. And people have saved time on the books already. If an employer, does the employer have to require the employee to take that time before the employee takes the paid FFCRA time? And the answer here is false. No, they cannot require the employees to take the time on the books first. They can save that time unless, and this goes to some of the questions we've been receiving from our CIRMA members, unless you have laid them off. And this is where I want to talk about what's the difference between a layoff and a furlough. A layoff is a permanent situation unless one day you recall the employees. And that's why it's called a layoff, because you don't necessarily know what the future holds. You hope to bring them back, but you just don't necessarily know whether you're going to be able to or not. So that's when they, you do everything typically that you would do if you were going to fire them, although it's not a negative. It's not their fault. They are leaving the organization. So they pack up their stuff and you do the termination paperwork and you let them go. And they go to unemployment and they file for unemployment. With a furlough, you can think of that as, you know, they are actually getting a temporary time off. And in this case, you know, they can't really go very far because we have to stay home. So, so they are, you know, basically getting and they still can get unemployment, but they are getting some time off and, you know, an unpaid leave of absence, if you will. But you are planning to bring them back. This is definitely a temporary situation. So for example, the groomers opened today, so I thought, and I called, made my appointment. I can't get in until June. So I went to our local PetSmart. Well, they're a corporation. So I went in there because I couldn't get on the phone and I couldn't get online because my dog looks like she was, you know, born in the 70s. And when I went in there, they said, well, we're a corporation. All of our groomers are furloughed and they haven't gotten approval to bring them back yet. So they're still, you know, temporarily laid off, but they're definitely coming back. So that's the difference. And I do have a couple of forms to give you an example of what you say different when you have a furloughed employee. You specifically do tell them this is temporary, it's an unpaid leave of absence, you know, here's the effective date, here's the date we expect you to come back. It might not be, you know, we're not going to promise anything, but here's what we're thinking. We'll continue to communicate with you. And then here's the layoff. And in a layoff situation, you may have an expected date of bringing them back. It may be no end date. You may not know at all. So so keep that in mind. But it is more of a permanent situation. The survey with SHRM showed that, you know, over 3 in 10 were being laid off, and 15% of employers had permanently cut headcount. That was at the beginning of April. So we're, you know, a month later. I'm sure the numbers have changed significantly, but this kind of gives you an idea. One of the things I will remind you about is think about how you have your employees set up with regard to the Fair Labor Standards Act, and make sure their exemptions are correct. We went through a lot of changes since 2016 and hopefully a lot of education since 2016 and this last year because of the threshold changes, trying to educate people about making sure that the exemption was correct. Because of the change in the threshold amount, we tried to make sure that people understood the duties test. Well, with regard to furloughing somebody who is an exempt salaried employee, you do need to make sure that you furlough them for the full work week. You cannot furlough them for incremental time frames. You can furlough a hourly employee for incremental times, but not a salaried exempt person. Remember, a salaried exempt person is getting paid to get the job done. They're not getting paid for a certain number of hours a week. So there's a difference in how they're getting paid. And that is how you should treat the furlough as well. Both a furlough and a layoff do qualify for unemployment. I would caution you to really think this through as far as what you can do. If you can send them home and work from home, try to do that. If you can, I have one company that sent them home with, just said, okay, unplug your computer and take it home and work from home and manage that process. But if you put them on unemployment and their current pay is less than what their Illinois unemployment plus the extra federal unemployment is, when you ask them to come back, they're probably going to be a little bit disgruntled, unfortunately. And that's an unfortunate situation that our government has put us in right now, but that is the reality of it. So keep that in mind. There's a lot of employers that are not, that are having trouble with employee morale because they are recalling employees back from furlough and back from layoff, and the paycheck is less than what they had when they were on unemployment and surfing their couch. So keep that in mind, but that is the reality of it. All right. It does say under most state laws, an employee who refuses a recall to work is disqualified for continued unemployment benefits. And I do believe that still is the case here in Illinois. As long as you provide them a suitable and bona fide job that they had before, then they will not be able to continue to get unemployment. So keep that in mind. The other thing is with regard to furlough, mostly with regard to layoff, I think you do need to contact your insurance brokers to find out how either one, depending on what you're thinking of, will impact your benefits for the employee, because your insurance brokers will know the answer to that question depending on how your benefits are written. And it could impact them positively or negatively. And COBRA could be affected. You may be able to pay the premiums for COBRA, as the question there says, but I would really talk to the insurance broker, because that's the person that's going to help you the best, and they're going to be able to also help you with the third point as well, with the Affordable Care Act, and I think the penalty. I think there has been some talk about the penalty being changed or not, not provided for you. So I don't know, but check with them. They are going to be the expert with regard to that. That will impact you as well. So if you have any severance policies, that may impact. A lot of private employers do not. I'm not sure about government. It may also impact for those government employers, IMRF, and other retirement plan implications for private employers. And then review if you happen to have any deferred comp, or if you have any written employment agreements or contracts regarding leave or termination. Be sure to review all that before you go into a furlough or a layoff. So all of those things have to be reviewed before you make some sort of decision related to that. Additional considerations are policy, communication. I do have a notice, which I had mentioned earlier, that I would give you. Documentation, I mentioned that, and also providing a notice to them about what the availability is. And then there should be a policy that how are you going to recall them, and in what way, in terms of seniority? Are you going to look at the positions? You know, is there going to be some kind of process for recall? The next thing talks about the CARES Act and the impact on hardship withdrawals. And I realize it's a 103, so we're over time. And we still have about 10 more slides. Nancy, what do you want me to do at this point? We've got a little bit more slides, but they are self.
I'd say continue with the presentation, and
Okay.
those who need to step out, they will, and the recording will be on the site this afternoon as well. So
Okay.
go ahead and deliver all the information you can, and thanks a lot.
All right, that sounds great. All right, so the CARES Act impact on hardship withdrawals. I know a lot of employees, especially because of what we just talked about, the furloughs and layoffs, there's a lot of employees that are having some financial anxiety, which is causing a lot of depression, and it has been impacting performance and morale. We need to, try to reassure them as much as we can. So the more we understand and know about these things, the more we can convey to the employees as well. So this question has to do with the CARES Act, and it allows for 401k or IRA hardship withdrawals for participants who are affected by COVID-19, including an exemption from income tax on withdrawal amounts, an exemption from the 10% early distribution penalty, an extended repayment period of 5 years, or all of the above. And actually, it is the 10% early distribution penalty. That's usually what people are always worried about, is not wanting to pay that penalty. So this is a really good thing to reassure them about, because if for some reason they go beyond the pay, their 2 weeks of paid time that the government gives them, and then they use up all of their paid time that they might have on the books, and there's nothing else left, and you're not ready to furlough or lay them off yet. What else do you do? Then you can tell them, well, you could still take a hardship withdrawal. That is one option. So they won't get a penalty with that. So something to consider. Sorry about that. I meant to put that up there. All right. The next thing is the Paycheck Protection Program. Remember, this is for you as the employer. It's part of the CARES Act and provides small businesses with partially forgiven loans that cover payroll costs, employer group health costs, and other expenses, are available for expenses incurred beginning February 15th, are available for businesses with fewer than 500 employees, and all of the above. And that is all correct. And the main thing is the majority has to be spent on employee-related expenses. There is a clause covering millions of American workers, and this is both for private and public, in the OSHA Act. This has been around for a very long time. One of the very first things over 30 years ago in HR, and it requires employers to furnish each employee with employment at a place of employment which are free for recognized hazards that are causing or are likely to cause death or serious physical harm. Is it PPE? Is it bloodborne pathogens, general duty, or communicable disease? It is general duty clause. So it's the general duty clause that is covering this this requirement for us to make sure we're protecting our employees from a communicable disease. Yes, we're using personal protective equipment to do that. It's not a bloodborne pathogen. It is actually an illness. A bloodborne pathogen is an illness in our blood. This is an actual in the air kind of thing. But 29 CFR 1910 section 5A1 is actually what part of the act it's in. All right. There was a memo that was issued April 13th that specifically addressed a lot of the issues related to coronavirus from OSHA, and it gave a lot of very detailed information. So if you want to look into that, that's the link for that. As I mentioned earlier, employee anxiety is huge problem right now for employers, and they are concerned about, what is the federal benefit time. An employee who is afraid of coming to work and contracting COVID-19, are they eligible for paid sick leave under FFCRA? This was a really big question, kind of right in the very beginning. How can I make my employees comfortable coming to work? And it was a lot of, you've got to reassure them. And the answer actually is false. They are not it's not a benefit for them to get paid just because they're having anxiety. You do have to reassure them. There are a lot of resources out there to help you, and there's a lot of questions on SHRM. That's going to be one of those management kinds of things, and their employee assistance programs available to help employers, but it is, it's not a benefit to do that. You just have to reassure them, provide them personal protective equipment, let them know why you're providing it, clean, all of the things that you need to do. These are a couple resources that I constantly use. The IPMA HR, that's specifically for public organizations. SHRM covers all organizations, and they have both have very specific coronavirus and COVID-19 specific resources, and a lot of forms that have already been developed for both types of organizations. There's a lot of really good posters that you can put out there, and this one specifically is a 2-page poster that is informative to try to prevent it. I had a client who had a guy with emphysema this week, and he is refusing to do the 6-foot distancing, and now the company is deciding that they're going to require the mask because the employees are just not doing the 6-foot distancing, even though they're requiring them to do so. And he's getting upset about that. Sometimes you have to sit down and talk to them and go through it. I don't know. But this is on prevention. The next couple are on symptoms, what employees should know. And I think there's some additional challenges. I think there's going to be things that we're going to, be struggling with for, a couple, 2-3 months, and maybe even into the fall about, managing communications, returning employees after, some furloughs and layoffs, maintaining that employee morale and company culture, struggling employees with mental illness, depression, feelings of helplessness, and productivity. So there's, certainly a lot going on with our employees, but, we're here to help as much as we can. So what kinds of questions do you have?
Thank you very much, Donna. And that was a wonderful presentation from Surma. We really appreciate you being engaged with us today. We have a long list of questions, and I just want to be sensitive to your time. So if you want to, I'll go back to the top. We had some at the very beginning.
Okay.
And you can tell us how your time for the day goes. But
Yeah, I'm here and available, whatever you need. I'm just trying to figure out how to get the chat box back up.
okay,
But
let
I
me
am-
start here. One of the questions that we had early on was back to the issue of harassment training. And the question was about whether township trustees need to do this as well, or whether they should just be concerned with OMA and Freedom of Information Act.
I'm not sure what OMA is.
Open Meetings Act, the Open Meetings Act, yeah.
Okay, yes. If the township trustees are working with any employees, then I would say yes.
Good, thank you. The next question after that is asking, you were talking about providing face masks in the work environment. What happens if you cannot obtain enough face coverings? We have them to start, but going forward, this may become questionable.
One thing I found out is that there is a lot of companies out there that are providing free masks, and I will provide a company that I just met yesterday that is in Southern Illinois that are providing free masks, and there's also Match.com has set up their organization so that they are they're matching people who need masks with people who are making masks. So if a company is in need of more masks, they can go to Match.com, just like they were trying to date someone, and go to the mask match part, and they can get matched up. But I also have this company I just met yesterday that's a manufacturing company, and they they went back to work just to make masks for people.
That's fantastic. We'll try to include that in the notes. There will be an email that will go out after today's session that will have the PowerPoints, all of those wonderful posters and handouts and documentation forms that Donna has provided to us will be made available to you. The next question is, if an employee has an underlying medical condition that prevents them from wearing face coverings, do they need to get a physician's order?
I think they do. Yeah, I had that question yesterday from one of my clients, and that's what the client asked for, is just to ask for a doctor's note.
Very good. Questions about what is considered a normal temperature. Is there a range, or does it have to be the 98.6?
I had seen 100.4, but I know the CDC actually does have a range, and I would go, I don't have it memorized, but 100.4 is what I saw on the documentation as I was looking through it today, but I would go, I can look that up for you.
Okay, thank you very much. There was a question about whether we would provide the quiz, and that's embedded in the PowerPoint, so you will have that, and it sounds like they want to use that in their local work there, so that's great. Let you know that you have great resources that you provided.
And also, if they want to find it, it's actually, if they go to the SHRM site and just put in the word quiz in the search engine and change it to recent, it's the very first quiz that comes up.
Awesome. Very good. That'd be a great exercise to be familiar with your website. A lot of great information.
Well, it's shrm.org, SHRM.org, not mine. But.
Okay, great. Thank you. So the stop poster, is it required to be posted or just provided as a courtesy?
That's a courtesy. That's not required.
Okay.
The second one is required though.
Okay. If an essential employee continues to come, does an essential employee have to continue coming to work when they are required to work within the 6 feet safe distance, yet the employer does not enforce workers to wear face masks or use other protective measures? Let me say that again. Did I jumble that? So does an essential employee have to continue coming into work when they are required to work within the 6 feet safe distance, yet the employer does not enforce workers wearing masks or using other protective measures?
I think in that case, the employee, if the employer is offering the job back to work, yes, they're going to have to work, but the employee should safeguard themselves. If the employer is not protecting everyone, then the employee can actually complain to OSHA. There is actually a complaint. That's part of what I found on the OSHA site.
Okay, makes sense. Are you saying that who is enforcing? So it sounds like OSHA may be the employer must provide face masks to the employee if they can't maintain the 6 foot distance. Who's enforcing that?
Most likely it will be OSHA, but it's the governor's office that put it out there. So I don't know, actually. I mean, I'm going to be honest there. I'm not sure. Oh, the employee can complain to OSHA because it's a safety precaution.
Okay, that makes
But I
sense.
don't know who's going, if anybody's going to be policing it.
Right, right. If so, it's only reported to OSHA if you know they contracted the COVID at work. You're not required to report it otherwise.
That's right.
I keep scrolling down through these.
And it's not reported to OSHA. It's just reported on your OSHA 300 log, which eventually will be reported to OSHA. But it's only reported to OSHA if the person is hospitalized or dies.
Okay, so the log documentation that you need to keep on file. Very good.
Yes.
Can the employee file for expanded family medical leave if they are not yet sick, yet their doctor declares them as high risk due to a pre-existing condition?
Not the expanded leave. If it has to do with a pre-existing condition and not COVID-19, the expanded leave has to do with COVID-19 only.
Okay. If you offered limited work from home during April and May during the shutdown for individuals who opted to stay home rather than come to work, whether due to a pre-existing medical condition or comfort level in coming in, can you on June 1st, assuming no extension, remove that option and no longer offer it?
Yeah. I don't see any reason why not.
Yeah, okay. Is a part-time hourly employee on furlough eligible for unemployment if it is their second job?
Yeah. I mean, I think they should be. I mean, they don't work, if they don't work there, like second job at the same place. We don't know that answer.
Yeah, you don't know the way.
Answer, but as long as it's a different place of work, yes, they should be. I mean, as long as they've been working part-time there for a long time, you know what I mean?
Yeah, okay.
So, yeah.
Does suitable include the employer providing PPE and proper social distancing?
Can you reread that one?
Does suitable include the employer providing PPE and proper social distancing?
Yeah, I'm not sure I understand the question, but the employer does need to provide PPE and require proper social distancing. I'm not sure where the suitable comes in.
So providing that safe work environment. Does the CARES Act apply to municipalities?
My understanding it does.
Okay, so we've got a community wanting. Let's see. I think we're just about to the end. What is an essential business is not providing or requiring employees to wear masks? What if, I guess, an essential business is not requiring that?
Well, I mean, they're taking a chance. It's just like I always, it's just like anything else. They're taking a chance of risking someone getting sick, and it coming down on them. So I don't know if there's going to be consequences. I don't know. You know what I mean? So
Right.
that's the big thing.
I think that covers the questions. Nancy, did you see any that I may have missed? We've got a poll just really quickly. If our participants could take this poll, it really helps us in garnering how beneficial today's discussion was. And I think it was very beneficial, the resources and tools that were provided. But we want to hear from you. It helps us in reporting out and documenting the value of today's programming. So with that, I'm going to say thank you very much for everyone in participating in today's webinar. You will receive an email using your registration address, and the recording should be available to you for you to share with others at your workplace within 2 to 3 business days from today's recording. So thank you very much to the Illinois Association of County Governments and to CIRMA for hosting today's webinar. Very much appreciate your involvement. Thank you, Donna and Kelly.
You're welcome.